Kind indulgence, my lord. I have challenged the Honorable Learned Single Judge's order. My final notification of my lord cargo, my black pepper writ petition has been dismissed, my lord. Throughout the writ petition, I have the benefit of the interim order. Because of the dismissal of the writ petition, now the customs authorities at Mangalore port, my lord, my black pepper received from Vietnam has been defreezed. Crores of rupees has been involved, my lord. I have also engaged senior advocate, my lord. Request from Friday or 3rd of July, my lord, because of urgency, my lord.
5th July.
My lord, 3rd, requesting for 3rd, my lord. 5th, please.
That's the writ appeal of the 2020-23. I'm the respondent number 3, Malan Damdasan. It's a matter arise of the Senior Citizen Act, wherein my parents have moved the assistant commissioner and got the gift deed executed in my favor was cancelled. That order has been set aside by the learned single judge, Malone. It's in my favor. The subject property is a residential and the commercial complex, because of which I was accruing rent. Based on rent, I was running my livelihood, because of that order has been set aside. This honorable court granted a stay by making some arrangement that is not feasible, my lord. I am also not getting any rent from because of this dispute, my lord. The tenants have been vacated, and my lord, some order needs to be passed, my lord. So I am just maybe permitted because the subject property is a commercial complex, my lord. And I was earning a rent from that because of this dispute, my lord. Please.
Matter with respect to that overseas Indian citizens, my lords, which your lordship heard. Lords, now the day
when it is coming up.
Lords, no date has been given, my lords.
It is not possible. Date has to be. Date
my lords, that day your lordships told us to mention, my lords, because of that BTC matter.
Date is not given.
Kindly taken up today, tomorrow, my lords.
No, date must have been given.
No, my lords.
It can't happen. You are mistaken.
My lords, sir.
Date is not given.
14170.
You are not giving date in each matter. Give date in each matter, even if it doesn't.
14170 of 24. Lords, the urgency is, my lords. Now the document verification have been started, my lords. Hence, my lords, I request for tomorrow, my lords.
Date is given. 28 June. It is coming up. In all matters, dates are given.
Please,
this court is concerned.
Lords, kindly. Lord, the
Yes,
contempt.
madam.
Content case of the year 2023. The complainants are engineers who have carried out work for the BBMP. But the
Contempt of 2023. So what do you want?
they have not complied with they have not filed a compliance affidavit, as well as they have neither complied
10th July. 10th July. Yes.
Adjournment, my lord. Serial number 34, my lord. Pen for respondent, I have intimated the petitioner, my lord. Any grant permission.
23rd July. Yes.
Lord, your kind leave. Contempt, my lord. Lord, I had filed in 156(3) application before the trial court. My lord, that came to be allowed. My lord, after getting allowed, the matter was referred to the CID. My lord, the said order is not been complied by the said commissioner, my lord, since December of last year, my lord, 2023. I had filed this contempt on April, my lord. My lord, the framing of charge of the trial court is posted.
6th August. 6th August. Not before. No urgency.
My lord, 1st August, the framing of charge is there. But the trial court will proceed against, not I am the defendant.
6th August.
Kind indulgence, my lord.
As a PL, madam, chairperson of the State Human Rights Commission is vacant
Pardon?
since long. Chairperson of the State Human Rights Commission, my lord, is vacant since long, madam, since it is a 2023 matter, madam. It's not yet come for the hearing.
What is vacant?
No, chairperson of the State Human Rights Commission, madam. Yes,
So
madam.
let it be. let it be
Number of
posted.
cases are pending before the honorable commission. Chairperson is not there, madam.
It will come on board.
A date may be given, madam. This is
you
because
filed-
2023 matter, madam. Notice was issued, but there is no further process of appointment in the.
23, all of it and urgency has cropped up.
No,
Going for 2 years.
complaints are pending. We have filed last year itself, madam.
It is lying idle.
Yes, madam, vacant. Yes, madam.
Why you are all of a sudden waking up?
No.
File IA.
I am, much older.
Yes, sir.
Kind in.
Little louder. Mic is there.
Serial number 30, Your Lordship. I appear for petitioner. I seek short accommodation.
It will go to 11th July.
Yes, yeah.
Kind,
Obliged.
kind mind, just, one RFA disposal matter, my lord. I filed an application for extension of time. 4 weeks time granted by the honorable bench, my lord, when dispose of the appeal, RFA. That time I have 50% of the amount I have deposited. Remaining amount I have, my brother has been expired. I could not arrange, my lord, because I have moved before honorable Mr. Justice Krishna Dixit's bench, my lord. My lord has directed me to move before my lords because some circular has been issued in respect of RFA matters, my lord. Therefore, any bench to be constituted for this matter, my lord. Otherwise, the execution to be filed by the respondent, I may be vacated, my lord. Therefore, one day, any date, my lord, convenient of the bench. my lord.
To approach learned registrar judicial.
Please, my lord. Please, my lord. Please, my lord.
Up before.
Please, please, grateful. my lord.
Serial number 25, my lords. The matter pertains to appointment of additional Upalokayaktas. my lords.
That the matter pertains, not we filed the PAL. The post was vacant for almost 1 year. Lord, your lordships intervened and the post is filled now. Honorable Mr. Justice Veerappa is appointed. The matter has become
We
infructuous.
do not know who is it.
Yes, I am making a.
How do you say that?
But it has become infructuous.
Tell it then.
Yes, it may kindly, we'll file a memo for
It
withdrawal.
is your knowledge, everything
Yes.
is your petition, your knowledge.
Yes.
Whatever you want to do, do.
We'll
it.
file a memo. my lord.
Don't make irresponsible statements.
Yes.
What do you want?
Withdrawal, we'll file a memo. We'll file a memo for withdrawal.
Whatever you do,
Yes.
why are mentioning that? There is nothing to be mentioned here.
Yes,
What you want to file a memo, file a
we'll
memo.
file a memo.
Contempt matter, seal number 1, Mr. Bhargav D. Bhatt. Appear for the complainant, my lords. I have, my lords, alleged the violation, my lords, of an order of a learned single judge of this court, my lords, dated 22nd March 2024, which is available at Annexure A, where, my lords, status quo was directed to be maintained in terms of the photographs produced along with the writ petition.
Learned additional government Peter is directed.
My lords,
to
private respondents.
take solicit the factual report and instruct the, and apprise the court on the next day. Put up on 5th of August.
Education matter, seal number 2, Mr. Suraj Sampath.
This is that matter?
Yes, my lord.
So what about the internal examination?
University which has not the, university which says not now, she is not eligible.
Why?
What has happened here, there's some, I think, clarity. The truth, one is, university should have approached the revenue authorities, Here, the student, she has done her 10th and 12th from Punjab, She's not a domicile of Karnataka. She has studied in Karnataka with respect to her undergraduate course,
Done from Punjab.
No, she's from 10th and 12th is from outside Karnataka, from Punjab. Her 5 years course.
Later, sir.
I'm sorry, that's her 5 years, her UG course, she started in Karnataka, she completed it. Now, she had secured, when she appeared for her PG NEET, with respect to the competitive examination, she secured about 37.7 percentile. The initial percentile, the cutoff was 40th. So there was a circular by the apex body of the Ayush courses, the NCISM. They have reduced the percentile to on 9/11/2020.
Then you filed your reply.
No, here, please, I can,
But what would happen is,
What?
order says one thing, my lord. Now what is sought to be supplied is not found in the
So
order.
therefore, which order?
No,
Annexure A, my lord. Annexure A is the basis for which I am removed, my lord.
may I suggest one?
It is also settled, my lord, that what is not found in the impugned order.
4/6/24.
4/6/2024, my lord.
Your Harnoor Kumar,
Kanur Kaur Mathur
your name.
is the petitioner, my lord.
Petition. Yes.
The only reason given, my lords, is that is not approved as your score is below the requirement for NEET percentage. The exam that I have written, my lords, is AIA PGET. On the basis of my AIA PGET score, my lords, I have been given admission. All my documents have been verified, my lords.
The KE has
Yes.
found me to be eligible.
That
The
is
second
reduced.
respondent itself issues me an eligibility certificate.
So is there case that he is supposed to pass NEET examination?
NEET, Malak, sir, we are calling it as All India Ayush Postgraduate Entrance Exam as NEET, Malak. I mean, just a nomenclature has been just changed because we say NEET for everything. For NEET, Malak, because the NEET is conducted for UG undergraduate level, it is by NEET only, Malak.
So he is not supposed to pass, nor is admission to be based on
No,
NEET
Malak,
result.
competitive examination, it requires, Malak. They need qualifying is her UG, competitive is the All India level entrance exam. So she has appeared in both. She qualifies. The only
So
dispute.
you answer that here and there, no,
No, Malak, so
neither here
only,
nor there.
Malak, so only, I would suggest only one thing, Malak, here the student has been admitted under the OBC category. As on 9/11, she was not qualified because her percentile was below 40th percentile. The 40th percentile cutoff for OBC category earlier was 40th, Malak. Thereafter, it was reduced to 35th percentile. She has, after the reduction of percentile, she has obtained a OBC certificate, Malak. That is a stage
cutoff-
scholarship. The OBC
Cutoff
certificate.
marks is 37.78.
I am eligible by virtue of the notification at Annexure D, my lord.
Malak, she has obtained the certificate itself is later, Malak. What I would.
It is prior to the cutoff date, my lord.
Yeah.
Annexure
Yes.
D, my lord, is that on 9/11/2023, they would reduce the percentile from 40 to 35, my lord. By virtue of which I become eligible to participate in this mop-up round of counseling. By
So what is,
virtue of
what is your stand?
Madam, my suggestion is, Malak, since she's taken an admission under the mop-up round in the management quota under OBC category, under the reduced percentile. She has taken the certificate, OBC certificate on 24/11/2023 after reducing the percentile. The percentile was reduced. Let her continue. At the meantime, let the university and the state government, Malak, the revenue department may look into her credentials, whether this certificate, what she's got is right or wrong, Malak.
What credential?
Malak, the OBC category, what she has
their own
taken.
certificate, Annexure
Malak,
C have produced the
she has
certificate.
the
my lord.
certificate, Malak's minimum qualification for a student and is to get a OBC in Karnataka, Malak, it would be 10 years to stay in Karnataka. She is admittedly 5 years only of study she has done.
Right, from 2007, her family has shifted to Bangalore, my lord.
Right down, highlighting the controversy and the issue involved. The court had occasion to pass the following order on 19/6/24 after hearing learned advocate Mr. S. Suresh for the petitioner. Then quote paragraph 2 to 6. The petition was posted on 24/6/24. And again today when learned advocate Mr. Whatever you.
Farafasa, the university, Malak.
So
So
and
it's
so
one
for the
number.
respondent number two university, whereas learned advocate Mr.
For respondent number 3, N.K. Ramesh.
N. Karamesh for whom?
Respondent number 3, Karnataka examination.
KE, my lord.
Karnataka Examination Board.
Lords,
Happy,
I undertake to appear on behalf of the college for the first
and
respondent.
so and so appears for respondent college. Course of the hearing. I propose in course of the hearing, in furtherance of the what is recorded in the aforesaid order, learned advocate for the petitioner submitted that mark 37.78 secured by the petitioner in OBC category brings the petitioner within the zone of eligibility in view of notification dated 9/11/23 into figuring at Annexure D, page 25, bracket over, figuring bracket. So he further pointed out that there is no dispute about the caste and the OBC category of the petitioner in view of certificate issued by the competent authority. Annexure C, page 24 of the petition. Full stop. Learned advocate reiterated. Learned advocates for the respondents. What is your stand?
Malak, one is Malak, and they have not challenged the discharge letter issued by the university in the petition at Annexure R, page 44, Malak. And second is, my lords, this, whether she, the caste certificate obtained by her after the reduction of percentile. She does-
Despite above, the learned counsels for the respondents doubted the veracity of the caste certificate, stating that it is obtained post.
No, not false, my lords. No.
Said in
Nothing
the-
is said, my lords,
Nothing
saying
is
that
said in the annexure R, page 44. They just say below percentile.
below
Nothing else.
percentile. She may not be eligible because she has taken the seat.
They
The
ought to have given
OBC
reasons.
certificate is from Karnataka, my lords, page.
The stand of the respondents orally submitted is that petitioner was not eligible on the date of entrance result, which was 8/8/23, since he had not scored 40% mark. This submission overlooks the aspect that by the aforesaid notification, the minimum cutoff mark for a OBC category were reduced to 35%, and the petitioner has scored 37.78%. Full stop. It was further pointed out by learned advocate for the petitioner that the impugned order into an annex array dated 4/6/24 only mentions that the admission of the petitioner for Panchkarma score, Panchkarma course is for the year 23/24, Panchkarma PG course for the year 23/24 is required to be disapproved in view of the fact that the score of the petitioner is below the requirement of NEET percentage. First of it was reiterated that NEET had nothing to do with the merit of the petitioner. NEET result is nothing to do with the merit of petitioner, and the petitioner is not concerned with the NEET examination. Full stop. The respondents are directed to file their reply. Full stop. In the meantime, by way of interim leave, it is directed in order to prevent irreversible situation for the petitioner, that the petitioner shall be permitted to appear in the internal assessment examination. The result and the appearance of the petition and the result which may be declared shall be subject to the further order and outcome of the petition.
To attend classes also, daily classes.
That was, so what does it mean? Petitioner shall be permitted to attend classes and also shall be permitted to appear in the internal assessment examination, which however shall remain subject to further orders and shall not create an equity in favor of the petition. Send over to 24th of July. When shall we give? Now there is an order, you can take the order. Their duty to inform whether we say or not. We are not saying anything and everything to the councils.
PL matter, still number 3.
Count hand service. Hand service is permitted. Hand service of this order is permitted.
Number 3.
Stand over to August, 6th August. Yes.
I appear for this is with regard to the post of member of the Karnataka Service Appellate Tribunal, Administrative Tribunal. In respect of these, the Supreme Court has passed an order.
Now, what is the strength of this members of the tribunal?
Members, now the judicial members, there are 3 judicial members are there. One is the chairman.
Here in the Karnataka, there is one bench.
But
How many benches are there? One single bench.
no, there are two benches. Are there.
Which are there?
That is, one is in Bangalore, main principal bench. Another is in Belgaum and another in Gulbarga.
Another in Gulbarga and
Gulbarga and Belgaum.
Padgam
Belgaum.
or Belgaum? Belgaum. Belgaum and Gulbarga. So this petition is for filling up the post of which? rank?
Now, this is in respect of principal bench. There are three judicial members.
Only principal bench, 3 judicial.
Now, out of these three judicial members, 2 members Lord, have attained the age of retirement.
They have retired.
Out of them, Lord, one of the members, Supreme Court has said that he shall be allowed to continue till the new appointments are made. Now, another judicial member, Lord, has retired only on 16th. Now, according to the Supreme Court order, they should continue the existing member till fresh appointments are made. The Supreme Court, my lord, as per the Supreme Court order, the existing members should be allowed to continue till new appointments are made.
Third member.
Yes, till the government makes new appointment. Supreme Court has said this right to access to justice is affected because of the delay in appointment. In those cases, the existing members, they should be allowed to continue till the new appointment, provided they are willing. That is the order made, my lord. That is in respect of the very same one of the members of the tribunal itself. Kindly see page 56. my lord.
Where is the order of Supreme Court?
Yes, page 56 is the order of the Supreme Court. In respect of one of the members of the principal bench of the tribunal. There, my lord, so and so counsel appearing on behalf of the petitioner state that apart from existing vacancy by 15th October 2022, there will be 2 further vacancies of judicial members in Karnataka State Administrative Tribunal which have not been filled up. As a result, it has been submitted, tribunal would be brought to a grinding. Then para 4 is a general order. Pending further orders subject to incumbents agreeing to continue in office, we direct in exercise of jurisdiction under Article 142 of the Constitution that existing judicial members shall continue to function till fresh appointments are made. And
Only one member is functioning.
now, out of these 3 members, Lord, 1 member is continuing by virtue of this order.
Today only one member is functioning because of the Supreme Court's order. Other 2 have retired.
2 members are there. 1 member is already there. His tenure is not over, chairman. Second member, Lord, is continuing by virtue of this order.
Supreme Court.
Third member, Lord, is just now retired about 10 days ago. And he should also be continued by virtue of this order. But the central government, in its communication.
No, what are the provisions about the appointment of chairman?
Yes.
Like that.
The appointments of the chair, they under the Administrative Tribunals Act. Section 5 of the
So what is the quorum?
part.
What is the quorum here?
The quorum is blood generally a division bench. That is 2 judges will sit. But in this,
After 10 days, there will be no tribunal.
no appointment has been made.
No tribunal.
Yes,
After 10 days, only one member will be functioning by virtue of.
2
the-
members are there. Only one chairman. Another member is continuing, but
After 10 days, what will happen?
yes, after 10 days. Yes,
What will happen?
yes,
That is your submission. After 10
yes,
days,
yes,
there will be only one member functioning by virtue of the orders of the Supreme Court.
correct.
Yes. So where is composition of tribunal? Read it, kindly read it.
Section 5 below deals with composition.
Yes.
Each tribunal shall consist of a chairman and such member of judicial and administrative members as the appropriate government may deem fit. Subject to the other provisions of this act, jurisdiction, powers and authority of the tribunal may be exercised by benches thereof. Subject to the other provisions of the Act, a bench shall consist of one judicial member and one administrative member. Notwithstanding anything contained in subsection 1, the chairman may, in addition to discharging the function of the judicial member or administrative member of the bench to which he is appointed, discharge the functions of the judicial member, or as the case may be, the administrative member or any other bench, may transfer the member from one bench to another bench, may authorize the judicial member or administrative member appointed to one bench to discharge also the functions of the judicial member or administrative member, as the case may be, of another bench, may, for purpose of securing that any case or cases which, having regard to nature of questions involved, require in his opinion, or under rules made by the central government in this behalf, to be decided by a bench composed of more than 2 members, issue such general or special orders as he deems fit, provided that every bench
We are
constituted.
not on the composition, we are on the mode of appointment.
Yes, mode of, then below section 6, qualification for appointment.
Mode of appointment, who will appoint, how will they are appointed? You are seeking appointment.
Yes. Mode of rules are lazy.
If you are not ready, come tomorrow.
Lord,
Very
here-
important matter, you are no, you can't.
No,
you
kindly
can't
see,
come-
Lord, we
you
are
can't
relying
raise
upon the
quotes now. Yes,
Supreme Court
next.
order with regard to
This
this.
small, you are not ready with this small query.
No,
that
no.
Which is the mode of.
The
appointment.
part of the Supreme
Because you are
Court.
seeking appointment in the, of the members of the.
No, no,
tribunal.
we are not seeking
And you
for
are not-
appointment. No, no, the point is, your lordship may kindly see, that is not the point on which I am arguing. I am saying that the existing member should be allowed to be continued till new appointments are made. I am not saying that new appointment should be made.
What else it is?
No, the Supreme Court, my lord, kindly see the order passed by the Supreme Court.
Such a petition not
No, no, the part,
to
the
be maintained.
direction of the Supreme Court is, let us see, my lord, the direction of the Supreme Court.
So you want the functioning person to Supreme Court or not? to function?
Yes, so long as the appointments are
Then
made, this,
Then there will be no functioning of the tribunal.
no, what I am saying is, till,
Member is already retired.
no,
The
my
other
lord,
judicial
let me
member is
make things
kindly
clear.
listen.
One member,
Kindly listen. One member is retired. The other is going to retire after 10 days.
my lord,
The
one
third
member
is-
has,
Third is functioning pursuant to the order.
no,
of
no,
Supreme
let me,
Court. Now you are saying that he should
no,
not
let me
function.
clarify, it is not so. Chairman is there, tenure is not over. Second member is continuing by virtue of the interim order passed by the Supreme Court. So there are 2 members. Third member has retired recently. As per the Supreme Court order,
Correct.
he should be continued according till the new appointments are made, is what Supreme Court says.
Such direction we can't give.
No, it is there by the Supreme Court order. Kindly see, my lord, the Supreme Court order, page 51.
Let us, it is only in respect of the one member.
No, no, it is, let us see, my lord, let us, you lordship may kindly, page 51 is the first order passed in respect of the Central Administrative Tribunal.
Page 52.
Now, page 51, the relevant portion is page 52, last para 5.
Yes.
The vacancies impinge upon citizens' right to access to justice. Hence, the court is of the considered view that is the exercise of the jurisdiction under Article 142 is mandated. We accordingly direct that pending further orders, the incumbents who are holding the post either of judicial member or administrative member shall continue to function even after completion of their tenures, subject to their consent and availability to act as judges. This arrangement is being made till the next date of listing, by which date is anticipated in terms of the statement which has been made on behalf of Union of India before this court, that vacancies would have been filled up. Now, this is the first order passed in respect of Central Administrative Tribunal. Kindly see page 54. The next order passed in page 55, relevant portion. Page 55, para 3. We direct that subject to the availability of judicial member, Ms. Badisha Banerjee and the administrative member, Dr. Nandita Chatterjee, their terms shall be extended till further orders until fresh appointments are made to fill up.
These are the 3 members.
What?
These are the 3 members today functioning.
Yes. Now, my lord, now the 3 members, this is in respect of the Calcutta Tribunal. In respect of Karnataka, page 56 is the order passed.
So Karnataka only.
Yes.
Unless you love Calcutta.
But
Yes.
Karnataka only, in respect of this bench, my lord, in respect of this matter at page 56. Now then on this basis, we also approached the Supreme Court. Supreme Court said, you anyhow we have passed an order, you approach the High Court. Kindly see page 67 is our order passed in our case.
Page 56 is Karnataka.
Page 56 is Karnataka.
So pending further orders and subject to incumbents agreeing to continue, okay, you direct the excise.
Yes.
That the existing jury members shall continue.
This is in the nature of an order in rem, my lord. This is not confined to a particular person.
True.
Then, my lord, because the third member, that is the, apart from chairman, two members are there, one member, Mr. Narayan Swamy, this order has been passed. Now the third member, another person by name Narayana, who is also a judicial member, has retired on 16th of this month.
What do you want now?
No, we say that let this, till the new appointments are made in the light of the same direction, my lord,
So it
can be passed in respect to the other judicial member also.
Those directions, as you say, they are in RAM, continuing.
They are in rem, but this government has not accepted. Kindly see, my lord, their endorsement, which is at page.
We don't, government is bound by the Supreme Court direction.
No, that is why, my lord, that is why I am before the court. Page 66 is their endorsement.
How do we say that the government is not acting upon the direction?
Page 66 is their letter.
66.
Paragraph 3. It may be observed that willingness of Sri Narayana for continuation of his service as member KSAT is on the basis of earlier direction of Honorable Supreme Court passed in WP zones. However, the said direction dated 13/5/22, so for a specific time period, same was also complied with by extending the tenure of members of CAT, KSCAT who are retiring at that time. There is no provision in the TRIR Act or rules framed thereunder for extension of tenure. Hence, the willingness furnished by Sri Narayana for continuation of his office as member is not in accordance with zone. However, in terms of section 6(1) of the TRI,
We really fail to understand why you are filing this petition. If they are terminating the services of members, contrary to the orders of Supreme Court, you can file contempt petition.
we filed, my lord, page 67. We approached the Supreme Court also.
67. They have not acted upon to terminate the services or discontinue services.
Page 67
67, let us see.
is the petition which was filed before the Supreme Court. Supreme Court said that even you have to approach the High Court.
This
So
is,
we said we will withdraw it with liberty to approach the
this is
Supreme
which
High-
petition? This has nothing to do with page 67.
No, this is the very same petitioner, my lord, has gone on the very same prayer.
For what purpose?
On the ground that the existing member should be continued till new appointments are made.
My lord, may I make one submission? My lord, to give a quietus to all this. If my lord, I'll take notice for respondents 3, 4,
We'll issue
and I'll
notice.
get back to my lord, if my lord could grant me some time.
Only point which remains to be dealt with is how do you deal with the Supreme Court?
Yes.
And how you are dealing with the Supreme Court. Nothing more. Notice returnable on. When shall we give? 9th of July? When the person is retiring?
No, we approached the Supreme Court. In the meanwhile, he retired on 16th.
Then 9th of July. Already retired. So he must not have conveyed his willingness to continue.
He has given the willingness, despite his willingness, the central government says, no, that order does not apply.
So this is a proxy petition. Proxy petition.
No, it is the Supreme Court, my lord, says access to justice is affected.
Take instruction.
Yes.
It is not, I am not saying that it should be continued forever. Let them make an appointment and close it. It is not in respect of a particular individual. If they say that we will appoint next week, then there is no need to continue.
Let us have. Once they have instructions, we can, yes.
Green bench matter, still number 4, Mr. Ravindra Gajanan Kolle.
Now, this is that which was heard.
Yes.
Now, just refresh the facts.
Yeah. May I submit, madam?
You may submit, yes, you are the petitioner. Let us, what is it about?
The petitioner was granted a query lease for a period of 5
This is
years.
arising from the order of the revisional authority. Arising from the order of the revisional authority.
Yes, madam.
Yes,
Yes,
where is
madam.
that order?
Yes, my lords.
Page 35.
Yes, my lords. May I read, my lord?
Page 35.
35, yes, my lords. Annexure A.
Yes.
That is the order of the competent authority, not the revisional authority.
It is not revisional order.
Revision is, it is in the first page, my lords. It is at page number 33 in Canaries and 35 in. It is competent authorities order.
No, no.
Revising authorities order is. Page 95, my lords.
Page 95.
Yes, my lords. At a relevant page at 97, my lords, it is typed version. Ninety-five is in Canaries and 97 starts in English, my lords.
English.
May I read, my lords?
Yes.
Second para. After verifying the documents in the file submitted by the competent authority, the applicant has been granted a query lease number 561 for a period of 5 years with effect from 25/3/2006 for ordinary building stones over an area of 1 acre in survey number 9 of so-and-so village, so-and-so district. The lease was expired on 24/3/2011. An application was made on 9/5/2013 seeking renewal of the query lease, and the competent authorities wide order number so-and-so dated 23/7/2014 has rejected renewal application as the same is not filed within the period prescribed under Rule 21(2) of AMMC rules. On 13/10/2014, the applicant has filed revision petition at number so-and-so against the said order. The petition, I think it must be petitioner. Petitioner died on 10/1/2016, and since the applicant was first renewal applicant was not disposed of, her husband, Shri so-and-so Ishwarappa, filed an application on 16/6/2016. The competent authority have rejected the second revision application, wide order number so-and-so dated 29/6/2016. As against the said order, the applicant has preferred revision petition on 4/7/2016. Next paragraph. The competent authority have submitted.
So on the ground that is not.
May I make
No, no,
submission in
let us-
order
yeah,
to?
You may, on the ground that it was not submitted within the time. Renewal.
Yes, renewal was not, it
Not
was.
filed within time.
So that is the ground of rejection.
That was the ground which was rejected in the year 2017. That order is not challenged before this honorable court. This is not under challenge. This is not under challenge. Your ask me kindly see the pair. There is the prayer, page number 29.
Once. Page 29, yes.
Prayer is issue a writ of certiorari or any other order, direction directing to pass or set aside the endorsement dated 27/12/2023, passed by the fourth respondent, the Deputy Director and Competent Authority produced
That
at
is
annexure
page 35.
35. That is the only annexure under challenge in this writ petition. Will ask me kindly peruse annexure A.
Yes.
Annexure A is dated 27/12/2023. It's wrongly typed as 13.
provisions of this rule. But I will start with the therein. Those two things are applicable to therein. Therein means sub-rule 1 to 7. This non-obstante clause is to be separately read or taken into consideration. That is the legislative intention. And nowhere in the legislature or nowhere in the earlier legislations, my lords, there are three categories of leases or licenses or query leases. Query leases is given to government lands. License is given to the patta lands. Mining leases is given pursuant to the Government of India notification, which came into force from 2015. In the light of that, my lords, this has to be read. The provisions of this rule, notwithstanding any contained therein, comma, we may have to stop therein, shall not apply to query leases or licenses or mining leases of minerals now classified as minor minerals. This is a single sentence without a comma. Query leases, licenses, or mining leases of minerals now classified as minor minerals, wide notification number so and so, granted before the commencement of 2016 rules, for which renewal has been rejected, comma, it has intentionally that has been put, or which has been determined, comma, or lapsed. These are the three categories. So the situation has arisen, my lords, in 2015, when Government of India reclassified 33 major minerals into minor minerals, my lords, the requirement of filing a renewal application was 24 months as per Rule 24A of Minor Mineral Concession Rules, my lords. So if you go back to 2015 and 24 months earlier, it is 10/1/2013 is the reckoning date. That is the reason, if they have not, major mineral mining leaseholders are not filed renewal application, then this sub-rule 8 has been brought into force, my lords. So in the light of this, my lords were pleased to ask me a question. If this benefit is given to all expired leases, there will be a big burden on the state legislature, my lord. The reason being, my lords, the legislative intention is that, my lords, prior to introduction of Rule 8C to 8K, that is systematic scientific mining closure plan, that was not there. There were several abandoned quarry leases left under the control of the state government or the department. Therein several casualties took place, several human deaths took place because they were abandoned. Now, thereafterwards,
here renewal application was rejected before 16. Yes. Here renewal application was rejected when?
17.
17.
First, I have produced that, my lord. It is mentioned.
After,
1 minute, my lord.
After the rules came into force, amended rules.
Renewal application was rejected in the year 2014. 14, and revision was rejected in the year 2017. Now, I'll clarify this Rule 8A.
No, before that, let me complete. My apologies, my lords, that I am taking little more time.
We are also taking more.
Sorry, my lords, because in the past, there have been such 2 or 3 occasions for this honorable court to pass similar orders. And at the, I am not going to comment anything on that, my lords. But this is the legislative intention.
We'll consider.
So herein, my lords, this rule, sub-rule 8 is a standalone thing which cannot be applied to commonly useful ordinary building stone or specified minor minerals or non-specified minor minerals. This is only in respect of reclassified minor minerals. On all earlier occasions, it was taken to a different direction, which I beg to differ.
Our learned advocate, Mr. Ravindra Gajanan Kolle for the petitioner, and learned government advocate, Mr. S.S. Mahindra for the respondent state and authorities of the state, whom I at length, learned counsels for the parties stated that they argued the petition finally. They further stated that the readings are complete and no further are required to be added or supplemented. Full stop, resort for judgment. Now we are reserving.
Writ appeal matter, still number 5, Mr. Kiran BS.
Yesterday it was there. Huh? 2 days ago.
My lord, I was able to trace one decision of the Honorable High Court of Madras, relying on the earlier 2 decisions, my lord. One is my lord, one is 1913 ILR 36 Madras, page 364. My lord, and another decision given by the English judges, my lord, that I'm not able to trace, but I have a copy, my lord, which says that there should be, my lord, evidence when the petitioner, evidence of 3 generations, if they have to, my lord, claim hereditary adjunctship.
So your maternal grandfather was
Yes.
same. But then where is the?
It is
rule of-
not the case that they have
Where is the
been.
rule of inheritance? This is some, for some puja. So where is the rule of inheritance?
My father, who was the son-in-law of my grandfather, was appointed under the previous act. Now, the previous act, if on the last occasion, I had placed before your lordships of the note. It's enactment, section 34. All your lordships, attention to that section. Section 34 of page 11 of the memo. No office of service to the Muslim institution shall be sent by hereditary right unless it has been conferred or recognized originally or has been held successively by 3 generations of the same family in successive course. It does not distinguish between paternal succession and maternal succession. So my father was appointed in 1979. Subsequently, in 1997 enactment, which was 2003, there was no provision related to hereditary succession. And there was nothing repugnant in the subsequent legislation that prevents or curtails my right to adjudication. I'm also relying on several judgments, my lord.
My lord, may I make one submission, my lord? My lord, admittedly, this order is appealable under section 25B7. My lord, the contentions that are being urged here
File your counter, heard learned resolution to notice. Notice is it? Notice returnable on 19th of July. Before the next date, counter affidavit from statement of objections will be filed.
Number 6.
Cooperative society में.
Oh, that election.
Election.
Two more.
Complete with the answer.
Number 7.
Your Lordship was pleased to permit me to make my submissions in reply in the last hearing date. Before my friends can start, my Lord, if Your Lordship permit me a few more minutes to only show the judgments which I seek to rely, my Lord. Only 2 more points to add whatever I have argued earlier, subject to Your Lordship's convenience.
You will have to give the synopsis. Your brief submissions.
I'll do that.
Both of you give. Your brief submissions.
Yes. Essentially an issue, my Lord, under the powers of judicial review, whether the proceedings said to have been filed before NCLT can be quashed. But on the point of lack of jurisdiction. So that will be, not Your Lordship had to look at what was the jurisdiction of NCLT, which I pointed out that the partnership firm is not yet been notified. Even in terms of their own petition, there is no such loan agreement, no guarantee deed. Therefore, the so-called calling of personal guarantor will not lie. But these are all the issues, which Your Lordship would like to look into as to arriving at the jurisdiction of NCLT. The moment, not if it is
This issue should be examined at which stage?
not under the powers of judicial. That is what I want.
Filing or at the stage of single judge or?
But that, if Your Lordship sees not the learned single judge's order for a moment, but that alone I will point out to Your Lordship. I'm grateful to Your Lordship. That page. That impugned order, internal page 21. What is it? It starts from page 21.
Page 21.
Page 21 order starts not. I refer to page 41, which is internal page. Page 41. Page 39 onwards, not page 39 onwards, which speaks about last paragraph. The effect of filing a petition. Page 39.
Yes.
Page 39, last paragraph.
Correct.
The effect of filing a petition under section 94 or 95 of the code is the immediate kicking in of section 96 of the code. 96 supra has some serious consequences. The moment a petition is filed under section 95 of the code, interim moratorium is axiomatic. Interim moratorium places any corporate debtor in a state of stillness as found in 96 1B of the code. Section 96 2 of the code mandates that when an application is made under 95, It shall operate against all the partners of the firm as on the date of the application. Yet another axiomatic consequence of petition being registered is appointment of a resolution professional. The moment an application is filed, the proceedings are immediately placed before the resolution professional and he would commence his functions of summoning of documents within so and so. These are the consequences of filing an application before the tribunal. I would emphasize that it is a consequence of filing the application and not entertaining the application by the tribunal. The tribunal that is empowered to entertain in part 3 is the debt recovery tribunal and not the first respondent tribunal. If it were to be a case of consideration of jurisdiction, when an application is entertained by the tribunal, it would have been altogether a different circumstance. Page 40, I am reading paragraph 14. If it were to be a case of consideration of jurisdiction, when an application is entertained by the tribunal, it would have been an altogether a different circumstance. The code is worded in such a way and hedged with such conditions that it leaves not play in the joints once the petition is registered before the tribunal. The statutory functions, its effect would immediately begin to flow. Both the learned senior counsels appearing for the respondent company have strenuously contended that it is, after all, filing of the petition. The tribunal will decide whether it has jurisdiction to entertain the petition or not. This court, at the stage of scrutiny of an application, should not entertain the writ petition. If filing of the petition did not result in any dire consequences, this court would have left it at that and directed the tribunal to decide the jurisdiction proceed further. That is not the purport of the code, as the petitioners and the like do not come within the ambit of the code. If they do not come within the ambit of the code, it touches upon the jurisdiction to even file a petition under 95 of the code by any creditor against a debtor. And if it is a question of jurisdiction, the answer to such question is always either yes or no. It can never be maybe. Learned counsel so-and-so contended that if a petition is filed before the tribunal, it is still at the stage of scrutiny. It has not even come up before the tribunal. I decline to accept the said submission as it is fundamentally flawed. If a quasi-judicial authority or a tribunal does not have jurisdiction to entertain a petition, merely because it is at the stage of filing, it cannot be permitted to proceed it further. If these submissions of the learned senior counsel is to be accepted, then it would be diluting the concept of jurisdiction itself. But having said that, not the other portions, not your lordship can skip and please come to the last portion, which is paragraph 19. At page 46, not paragraph 19 at 46. The maintainability of the petition before the tribunal cuts at the root of the matter as it relates to jurisdiction to entertain a petition by the tribunal. The code does not permit it. If that be so, even a speck of paper cannot move before a fora that has no jurisdiction. It is ununderstandable as to how and why a petitioners have to go before the tribunal and tell the tribunal that it has no jurisdiction to entertain the petition. The very acceptance of the filing by a tribunal is contrary law. Therefore, not the orders can be passed. At this note, I will fortify your lordship by referring to the judgments as to the powers of judicial review whenever an issue of jurisdiction has come. But the other day, I pointed out to your lordship one judgment. But then I have got a compilation of judgments which your lordship permits not, I can point it out. And I will only show relevant paragraph, not I will not take a lordship much of the time. In the first judgment, please come to page 4, paragraph 5. Yes, Govinda Menon versus Union of India. Page 4, paragraph 5. The jurisdiction for grant of a writ of prohibition is primarily supervisory, and the object of that writ is to restrain courts or inferior tribunals from exercising a jurisdiction which they do not possess at all, or else to prevent them from exceeding the limits of their jurisdiction. In other words, the object is to confine courts or tribunals of inferior or limited jurisdiction within their bounds. It is well settled that the writ of prohibition lies not only for excess of jurisdiction or for absence of jurisdiction, but the writ also lies in case of departure from the rules of natural justice. And in our case, it is a clear case of absence of jurisdiction. Code itself specifies in cases of partnership form under Part 3, it is only the DRT. Only exception to Part 3 was personal guarantors to corporate debtor. That was vested with NCLT in terms of Section 60, subsection 2. Here the case is effectively they are projecting that there is a partnership form. Dehorse not that there is no guarantee deed. They refer to some agreement. Say that partnership firm is a liability. Therefore, the partners are held to be personal guarantors. But this is far-fetched imagination to vest a jurisdiction which is not there. Let the next judgment starting from page 17. At paragraph 334 at page 211. Mafatlal Industries, which also referred to the earlier judgment which I had pointed out. Relevant is at paragraph 334 at page 211. At page 211. Opinions may differ as to when it can be said that in the public law domain, the entire proceedings before the appropriate authority is illegal and without jurisdiction, or the defect or infirmity in the order goes to the root of matter and makes it the law invalid or void, referred to so-and-so. The matter may have to be considered in the light of provisions of the particular statute in question and the fact situation obtaining in each case. But in our case, provisions of the particular statute clearly holds that there cannot be a jurisdiction vested with NCLT. And fact situation also, my lord, clearly establishes that what could not be directly done, they are trying to bring in indirectly as if NCLT has a jurisdiction. It is difficult to visualize all situations, and I'm just continuing to read in the same paragraph 334. It is difficult to visualize all situations hypothetically and provide an answer. Be that as it may, the question that frequently arises for consideration is, in what situation cases the non-compliance or error or mistake committed by the statutory authority or tribunal makes the decision rendered ultra vires or a nullity or one without jurisdiction. If the decision is without jurisdiction, notwithstanding the provisions for obtaining reliefs contained in the Act and the ouster clauses, the jurisdiction of the ordinary court is not excluded. So the matter assumes significance since the landmark decision in Anisminic Limited versus Foreign Competition Commission, the legal world seems to have accepted that any jurisdictional error, as understood in the liberal or modern approach laid down therein, makes a decision ultra vires or a nullity or without jurisdiction, and the ouster clauses are construed restrictively, and such provisions, whatever their stringent language be, have to be held not to prevent challenge on the ground that the decision is ultra violence and being completely nullity if it is not a decision within the meaning of the Act. The concept of jurisdiction has acquired new dimensions. The original or pure theory of jurisdiction means the authority to decide, and it is determinable at the commencement and not at the conclusion of the inquiry. The said approach has been given a go-by in the Anisminic case, as we shall see from the discussions here and after. Judicial review versus so-and-so. Then next paragraph, after the extracted portion. The decision in Anisminic case has been cited with approval in a number of cases of this court. They have given the entire gambit of law as taken out by the Supreme Court referring to that judgment. And the extracted portion, which is paragraph 10 of the extracted portion. The word jurisdiction is a verbal cast of many colors. Jurisdiction originally seems to have had the meaning that Lord Bade ascribed to it in Anisminic Limited, namely the entitlement to enter upon the inquiry in question. If there was an entitlement to enter upon an inquiry into question, then any subsequent error could only be regarded as an error within the jurisdiction. The best known formulation of this theory is made by Lord Denan in R versus Bolton. He said that the question of jurisdiction is determinable at the commencement, not at the conclusion of inquiry. Therefore, my lord, in our case, my respectful submission that there is a determinable question of jurisdiction at the commencement. The very filing, my lord, is wrong in terms of the provisions of the court and their own filings, their own plea case which has been pleaded. Then over the page, my lord, page 213, yet another extracted portion of the English law, but starting in the second paragraph. In the same case, Lord Pierce said, lack of jurisdiction, page 213, my lord, second paragraph. Lack of jurisdiction may arise in various ways. There may be an absence of those formalities or things which are conditions precedent to the tribunal having any jurisdiction to embark on an inquiry. Or the tribunal may at the end make an order that it has no jurisdiction to make. Or in the intervening stage, while engaged on a proper inquiry, the tribunal may depart from the rules of natural justice, or it may ask itself the wrong questions, or it may take into account matters which it has not been directed to take into account. Thereby, it would step outside its jurisdiction. It would turn its inquiry into something not directed by the parliament and fail to make an inquiry which the parliament did direct. Any of these things would cause its purported decision to be a nullity. The dicta of the majority of the House of Lords in the above case would show the extent of lack and excess of jurisdiction. Therefore, courts have seen in the context of whether there is lack of jurisdiction, whether there is excess jurisdiction being exercised. That is where they try to distinguish as to whether it is in the commencement stage or whether it proceeds further. But then the third judgment at page 225, that relevant paragraph would be 239. This is IFCO Limited versus Badra Products, which again was referred to in many judgments. Page 239, paragraph 21. Which again starts about that jurisdiction is a coat of many colors and that the said word displays a certain color depending upon the context in which it is mentioned is well settled. It is the classic sense, the official trustee was Sachendranath Chatterjee, jurisdiction is stated to be. In the order of reference, that your lordship can skip not only for the point of jurisdiction, I will not trouble your lordship on that. But then comes the judgment in page 246, which is relating to a provision under IBC and which was concerning a decision of this honorable court, my lord, in the case of embassy property development. And this was a matter where, my lord, a cancellation of mining lease was sought to be questioned before the NCLT. But NCLT decided the issue, as against which a writ petition was filed before this honorable court. But a plea was taken saying that it is only an appeal remedy which is available. Therefore, the High Court could not have entertained the writ petition. In that context, the matter went to the Supreme Court. But relevant paragraph is page 259, immediately after paragraph 259. Case of embassy property development versus state of Karnataka. (259) immediately after paragraph 12. The very context in which Supreme Court had looked into in this decision is that not whether a writ petition was maintainable before the High Court in respect of a proceedings before the NCLT. Now, in that context, not jurisdiction and the powers of High Court under Article 226 is the heading immediately after paragraph 12. What is recognized by Article 226(1), paragraph 13, my lord? What is recognized by Article 226(1) is the power of every High Court to issue directions, orders, or writs. They can be issued to any person or any authority, including the government. They may be issued for any enforcement of any rights conferred under Part 3 and for any other purpose. But the exercise of the powers recognized by Clause 1 of 226 is restricted by the territorial jurisdiction of the High Court. Now, having said that, not paragraph 14. Traditionally, the jurisdiction under Article 226 was considered as limited to ensuring that the judicial or quasi-judicial tribunals or administrative bodies do not exercise their powers in exercise of their statutory limits. So this paragraph spread about what any person means. Then over the page, my lord, paragraph 15. On the first paragraph, my lord, territorial jurisdiction was considered. Then whether any person under 226, my lord, the writ would lie. Then 260, paragraph 15. One of the well-recognized exceptions to the self-imposed restraint of the high courts in cases where a statutory alternate remedy of appeal is available is the lack of jurisdiction on the part of the statutory quasi-judicial authority against whose order a judicial review is sought. Traditionally, English courts maintained a distinction between cases where a statutory quasi-judicial authority exercised a jurisdiction not vested in it in law and cases where there was a wrongful exercise of available jurisdiction. An error of jurisdiction was always distinguished from in excess of jurisdiction until the advent of the decision rendered by the House of Lords by a majority of 3:2 in Anismenic Limited versus Foreign Compensation Commission. After acknowledging that the confusion had been created by the observations made in R versus Governor, to the effect that if a tribunal has jurisdiction to go right, it has jurisdiction to go wrong, it was held in Anismenic that the real question was not whether an authority made a wrong decision, but whether they inquired into and decided a matter which they had no right to consider. Anismenic, hailed as a breakthrough and a legal landmark, see Rakal versus Communications, abolished the old distinction between errors of law that went to jurisdiction and errors of law that did not. Anismenic was hailed in O'Reilly to have liberated English public law from the fetters that the courts had therefore imposed upon themselves so far as determination of inferior courts and statutory tribunals were concerned, by drawing exoteric distinctions between errors of law committed by such tribunals that went to their jurisdiction and errors of law committed by them within their jurisdiction. But Rakal in re made a distinction between courts of law on the one hand and administrative tribunals, administrative authority on the other hand, and held insofar as inferior courts of law are concerned, the subtle distinction between errors of law that went to jurisdiction and errors of law that did not would still survive if the decision of such courts are declared by a statute to be final and conclusive. Thus, one distinction was gone with Anismenic, but another was born with Rakal in re. This could be seen from the after effects in Anismenic. Interestingly, just 4 days before the House of Lords delivered the judgment in Anismenic, an identical view was taken by the 3-member bench of this court, delivered in the official trustee versus Sachindranath Chatterjee, approving the view taken by the full bench of Calcutta High Court in Hridaya Nath Roy versus Ramchandra Sharma. It had held therein, before a court can be held to have jurisdiction to decide a particular matter, it must not only have jurisdiction to try the suit brought, but must also have the authority to pass the order sought for. Not pausing for a moment, if your lordship applies this situation to the fact that as to the present case, one is the lack of jurisdiction by which it could not entertain. And if at all, if it is to be found that the NCLT has to decide, and ultimately the decision which they could make. And if the court says that the NCLT has no jurisdiction insofar as partnership firms are concerned, but there will not be any authority for the NCLT to pass any order, be it whatsoever. Then at page 262, the Supreme Court records what are all the other further judgments which had been considered in the flow of as well as the march of law which occurred. Finally, my lord, at paragraph 22 in 262, but it's relevant to note that official trustee / Anismenic and what followed both were mostly in the context of power of superior court to interfere with the decision of subordinate court, tribunal or administrative authorities. Most of these decisions were not in the context of exercise of jurisdiction, despite the availability of alternate remedy. That there exists such distinction between cases where the jurisdiction of superior court is questioned on the basis of ouster clauses and cases where the exercise of jurisdiction by a superior court is questioned on the availability of alternate remedy was recognized even in Anismenic, when Lord Reid referred to the decision in Smith versus so-and-so as posing some difficulty. At the final 4 lines, therefore, the question whether the error committed by an administrative authority, tribunal or a court of law went to jurisdiction or whether it was within the jurisdiction may still be relevant to test whether a statutory alternate remedy should be allowed to be bypassed or not. But all these things in the context of the judicial review which your lordship will exercise. Then finally, in paragraph 24, my lord. Therefore, insofar as the question of exercise of power conferred by Article 226, despite the availability of a statutory alternate remedy is concerned, anismenic cannot be relied upon. The distinction between the lack of jurisdiction and the wrongful exercise of available jurisdiction should certainly be taken into account by high courts when Article 226 is sought to be invoked, bypassing a statutory appellate remedy provided by a special statute. Because that case, my lord, was a provision, was an order of the NCLT challenged before the High Court instead of going before the NCLAT. Therefore, my lord, the court said what is to be looked into. Then finally, my lord, the fifth judgment, which is at page 275 of the year 223, my lord, which referred to all these earlier judgments, relevant your lordship may consider from paragraph 53 onwards, my lord. Just for a note, my lord, I'm just leaving it. I'm not troubling because it goes into some length. From 53 onwards, one paragraph which I can read to your lordship is 309, paragraph 58. 309, paragraph 58. From the aforesaid, it could be said in terms of jurisdictional error that want of jurisdiction may arise from the nature of subject matter, so that the inferior court or tribunal might not have the authority to enter on the inquiry. Page 309, paragraph 58. But this is precisely which will fall for consideration as far as our case is concerned. From the aforesaid, it could be said in terms of jurisdictional error that want of jurisdiction may arise from the nature of subject matter, so that the inferior court or tribunal might not have authority to enter on the inquiry. It may also arise from the absence of some essential preliminary or jurisdictional fact. When the jurisdiction of a body depends upon a preliminary finding of fact in a proceedings for a writ of certiorari, the court may determine whether or not that finding of fact is correct. The reason is that by wrongly deciding such a fact, the court or tribunal cannot give itself jurisdiction. But this will sum up the entire issue, my lord, at the first instance as to the want of jurisdiction in terms of the provisions of the code, and at the second instance, admitted facts which I pointed out to your lordship from their own pleadings, even in the NCLT petition, that there is no personal guarantee by any of the parties. There is no invocation of any such personal guarantees. But for that limited purpose, the Honorable Supreme Court in this paragraph 58 said that you may have to, finding of fact has to be considered. But if your lordship permits, not one more judgment which it was handed over separately, not already given.
Along with the bound book separate.
There were two judgments along with the bound book given. 1954, 1 SEC 905. Separately given. Do you have one of the two copies? 1954, 1 SEC 905. Yes. I'm sorry for the inconvenience. But this gives a very interesting reading as to.
TC Basappa.
Yes, ma'am. Yes, ma'am. TC Basappa versus Nagappa and another. A very interesting read as to the issue of certiorari. Starts from paragraph 4, my lord. Third page of the judgment, paragraph 4. The substantial contention raised, paragraph 4 at third page. The substantial contention raised who appeared on support of the appeal is that the learned judges of the High Court misdirected themselves both on facts and law in granting certiorari in the present case to quash the determination of an election tribunal. It is urged that the tribunal, in deciding the matter in one way, it did not act either without jurisdiction or in excess of its authority, nor was there any error apparent on the face of the proceedings which could justify the issue of to quash the same. Therefore, last line again, last line. 2 points really arise for consideration upon the contentions raised in this appeal. The first one is, on what grounds could the High Court, in exercise of its powers, under Article 226 of the Constitution, grant a writ of certiorari to quash the adjudication of the election. I was reading from the following page. The second is whether such grounds did actually exist in the present case and are the High Court's findings on that point proper findings which should not be disturbed in appeal. The principles upon which the superior courts in England interfere by issuing writs of certiorari, paragraph 5, paragraph 5. The principles upon which superior courts in England interfere by issuing writs of certiorari are fairly well known, and they have generally formed the basis of decisions in our Indian courts. It is true that there is lack of uniformity even in the pronouncements of English judges with regard to the grounds upon which a writ, or as it is now said, an order of certiorari could issue. But such differences of opinion are unavoidable in judge-made law, which has developed through a long course of years. As is well known, the issue of prerogative writs, within which certiorari is included, had their origin in England in the king's prerogative power of superintendence over the due observance of law by its officials and tribunals. The writ of certiorari is so named because in its original form it required that the king should be certified of the proceedings to be investigated, and the object was to secure by the authority of a superior court that the jurisdiction of the imperial tribunal should be properly exercised. These principles were transplanted to other parts of the king's domains. In India, during the British days, the 3 chartered high courts of so-and-so were alone competent to issue writs, and that too within the specified limits and the power not exercisable by the other courts at all. In that situation, as this courts observed in Election Commission versus so-and-so, the makers of the Constitution, but that your lordship can skip the extracted portion, then paragraph 6. The language used in Article 32 and 226 of our Constitution is very wide, and the powers of the Supreme Court as well as of all the high courts in India extend to issuing of orders, writs and directions, including writs in the nature of habeas corpus, mandamus, quo warranto, prohibition and certiorari as may be considered necessary for the enforcement of fundamental rights, and in the case of high courts, for other purposes as well. In view of the express provision of our Constitution, we need not now look back to the early history of the procedural technicalities of these writs in English law, nor feel oppressed by any difference or change of opinion expressed in particular cases by English judges. We can make an order or issue a writ in the nature of certiorari in all appropriate cases and in appropriate manner, so long as we keep to the broad and fundamental principle that regulate the exercise of jurisdiction in the matter of granting such writs in English law. One of the fundamental principles in regard to issue of writ of certiorari is that the writ can be availed of only to remove or adjudicate on the validity of a judicial act. The expression judicial acts include the exercise of so-and-so. But then paragraph 8. The second essential feature of writ of certiorari is the control which is exercised through its judicial or quasi-judicial tribunals or bodies is not in an appellate but supervisory capacity. In granting a writ of certiorari, the superior court shall not exercise the powers of an appellate tribunal. It does not review or reweigh the evidence upon which the determination of imperial tribunal purports to be based. It demolishes the order which it considers to be without jurisdiction or palpably erroneous, but does not substitute its own views for those of the inferior tribunal. The offending order or proceedings, so as to say, to put out the way as one which should not be used to the detrimental of any person. The supervision of the superior court exercised through writs of certiorari goes on 2 points, as has been expressed by Lord Summer in R versus Natbell. One is the area of inferior jurisdiction and qualifications and the conditions of its exercise, and other is in the area of law, in the observance of law in the course of its exercise. These two heads normally cover all the grounds on which writ of certiorari could be demanded. In fact, there is little difficulty in the enunciation of the principles. The difficulty really arises in applying the principles to the facts of a particular case. Certiorari may and is generally granted when a court has acted without or in exercise of jurisdiction. The want of jurisdiction may arise from the nature of subject matter of the proceedings, or from the absence of some preliminary proceedings, or the court itself may not be legally constituted or suffer from certain disability by reason of extraneous circumstances. When the jurisdiction of the court depends upon the exercise of some collateral fact, it is well settled that the court cannot, by a wrong decision of fact, give it jurisdiction which it would not otherwise possess. But pausing for a moment, instead of the court here, the appellant before lordship is seeking to give such wrong facts to confer a jurisdiction. When apparently there is no jurisdiction of NCLT for a partnership firm, The petition before the NCLT will be couched in a manner.
Paragraph 11.
Yes, ma'am. A tribunal may be competent to enter upon an inquiry, but in making the inquiry, it may act in flagrant disregard of rules of procedure, or where no particular procedure is prescribed, it may violate the principles of natural justice. A writ of certiorari may be available in such cases. An error in the decision or determination itself may also be amenable to writ of certiorari. These are all cases where subsequent to that, they commit an error in exercise. But we are at the threshold stage as to the very want of jurisdiction and fact situation which the appellant tried to bring about as if, my lord, that there is a jurisdiction vested with the tribunal. Therefore, my lord, my respectful submission, my lord, as to the fact situation I had pointed out, the decision of the learned single judge was precisely in this contention that ultimately the tribunal can decide, where the single judge gave his own reasonings, that there is something which immediately kicks in the moment a filing is done. Because 96 of the code says the moment a petition is filed, and that is the mischief they are trying to do. The very entire exercise, as I pointed out, is that file a petition and claim before the arbitral tribunal that there is a moratorium, you cannot proceed. Now, this act of seeking to stall the arbitration was also done in another manner, saying that your mandate is over. That matter went up to the Honorable Supreme Court, and not, in fact, the writ petition was dismissed by this Honorable Court with a cost. And Supreme Court also, my lord, dismissed the appeal which they had filed. So this is a repeated exercise which they are trying to do at one stage or other, just to derail the process of the arbitration. Therefore, my lord, in my respectful submissions, my lord, I would only pray your lordship that the writ appeal be dismissed. And before the arbitration tribunal, my lord, on facts, the so-called guarantee was not even pleaded. There is not even one single pleadings in their statement in their pleadings before the arbitral tribunal that there was some guarantee. Nothing is said so. And subject to lordship's convenience, my lord, I will file a notice of submission of convenience. Obliged.
Today, the entire argument that is certiorari demolishes an order of the authority without jurisdiction. And that writ of blood prohibition proceeds against the inferior court or tribunal on a finding of fact. But this is the precise submission by me. The writ petition at paragraph 23 says, being wholly aggrieved by the administrative act of the first respondent in receiving the petition filed by the second respondent and consequent order of the second respondent claiming that this is the petition which is directed against an administrative act of the receiving branch of the NCLT. The entire argument is targeted against an NCLT exercising the power on a finding of fact, and which can be questioned by a writ of prohibition. And a certiorari demolishes an order without jurisdiction. But kindly similar, this is the reason why, my lord, I wanted to point out the mechanism under the IBC which provides for self-contained enactment for a period of 41 days. That's all. Only 41 days. Can I take your lordships to 4 sections, my lord? 4 subsections, not even sections. What happens when the file? This petition filed by me is not even placed before the NCLT, before the learned judges. There is not even an order sheet opened. Absolutely nothing is done. Therefore, today's argument that certiorari lies and prohibition lies, but this cannot lie against an administrative act. Kindly similar to section 97. What happens when I file the petition? When a petition is filed against the personal guarantor of a corporate debtor, 97 subsection 3, when an application under section 94 or 95 is filed by the debtor or the creditor himself, as the case may be, or not through the resolution professional, the adjudicating authority, that is the NCLT, shall direct the board, that board of within 7 days of the filing of the application, to nominate a resolution professional for the insolvency resolution process. Here, my lord, the time span is 7 days. Then kindly say section 97, 4. The board shall nominate a resolution professional within 10 days of the receipt receiving the direction issued by the adjudicating authority under subsection 3. Blood, another 10 days is added. It may be less than that because the outer limit is 10 days. There also outer limit is 7 days. Kindly see, now section 99. The resolution professional, subsection 1, the resolution professional shall examine the application referred to in subsection 94 or 95 as the case may be within 10 days of his appointment and submit a report to the adjudicating authority recommending for approval or rejection of the application. Blood, here 10 days. Now kindly see section 100. The subsection, the adjudicating authority shall within 14 days from the date of submission of the report under section 99 pass an order either admitting or rejecting the application referred to in subsection 94 or 95 as the case may be. Therefore, Lord, 7 plus 10 plus 10, 14, 41 days. This is all. This, the moment a report is submitted before the NCLT, but the NCLT may accept the report or reject the report. There is an inbuilt mechanism provided in the act itself the moment an application is filed. Therefore, it has not even gone before the NCLT. Now, the only question, well, 2 submissions were made. This submission that I have invoked chapter 1 of part 3 was made before the learned single judge and it is reiterated before Lordship. This submission prompted the learned single judge to frame a particular question, but I will draw your Lordship's attention to that particular question framed by learned single judge at page number 31. That my petition was an insolvency proceeding against a partnership concern, which provision is not yet notified. Therefore, the learned single judge framed the question whether a petition against a partnership firm or its director is fileable and maintainable. This is the question framed. Like it is nobody's case. I agree with my friend that against a partnership concern today insolvency proceedings cannot be initiated because that chapter 1 is not notified. What is notified by way of a notification issued by the central government is that I can file a petition against a personal guarantor of a corporate debtor. This is nobody's case that we are challenging we are filing the petition against a partnership concern. Now, kindly see, my lord, what happens once the scheme, my lord, within 41 days takes place, then it goes before the NCLT. The NCLT may accept the report and then continue the moratorium. Now, the second argument is that there is no loan agreement. Kindly see, my lord, section 3, subsection 37 of the IBC. Section 3, subsection 37 of the IBC. Let words and expressions used but not defined in this code, but defined in the Indian Contract Act, the Partnership Act, the rest of them that I will skip, shall have the meaning respectively assigned to them in those acts. Now, under section 126 of the Contract Act, a guarantee can be even written or oral. I will just read that portion, my lord. The last line in paragraph in section 126, a guarantee may be either oral or written. Section 126 of the Contract Act. Now, the entire provisions of the Partnership Act and the Contract Act are lifted and incorporated in the IBC. Section 3, my lord, 37. Those is a special legislation, my lord, the provisions of the Contract Act, the Partnership Act, are lifted and incorporated within the IBC provisions. Now, 126, my lord. Lord, it defines a contract of guarantee is a guarantee to perform the promise or discharge the liability of a third person in case of default. The person who gives the guarantee is called surety. The person in respect of whose default the guarantee is given is called a principal debtor. and the person to whom guarantee is given is called the creditor. A guarantee may be either oral or written. Now, I draw your lordship's attention to the loan agreement itself. Now, that is the entire gamut of the argument of my learned friend at page number 685, volume number 2.
Guilty evidence is laid or not?
It's not like, no.
No. It's a summary jurisdiction.
Pardon?
It's a summary jurisdiction.
Well, under the-
Judgments, my lord, the latest being Oswald's case, Aruna Oswald's case, the Honorable Supreme Court, my lord, held the NCLT being a summary jurisdiction and it's a tribunal. It cannot decide, my lord, complex questions like questions of title, etc., which necessarily requires a larger jurisdiction, which is, my lord, bestowed only upon plenary courts.
Lord, my friend the other day used the word borrowed legislation. Lord, your lordships are under 1956 Act.
So that factor goes against you. That it is summary jurisdiction.
I will satisfy your lordship. My lord, this question, my lord, it fell from your lordships, my lord. I have made some small notes, my lord. I will satisfy your lordship.
It might go against you. That it is only summary jurisdiction.
I shall.
But there is an inquiry by the RP where both the creditor and the debtor is given an opportunity.
This was
He
gone
will
into
issue
the-
note. He will issue notice to both the creditor and also the personal guarantor of a corporate creditor. Then he will prepare the.
Your argument that the contract may be oral or written. Then
Yes, certainly.
who will examine that? In
That the RP will decide.
In absence of power to lead evidence.
The RP will decide. Now the question is this. Now kindly see, my lord, your lordship express the view that the power of a inferior court cannot be taken over by the High Court under Article 226. This is what exactly they want the High Court to do. The
Like the tribunal of record.
No, the power of the RP or whatever the duty of the RP, the petitioners want this honorable court to exercise. This is what I pointed out section 96, 7 to 100. It go within 7 days. RP will be appointed, the direction will be issued by the NCLT to the board to appoint the RP. Within 10 days, the board will appoint. Then within 10 days, the RP will submit the report. Then within 14 days, the NCLT either accept or reject. But why can't they wait for 41 days so that the institutional mechanism provided under the NCLT, under the IBC, is followed in letter and spirit? The Milord, we are not on Milord institutional.
My friend can answer only one point.
But I did not.
22/11 it is filed. They claim immediate moratorium. Writ petition, my lord, is on 7/12.
There was a stay by the learned single judge for 77 days of the arbitration. Let they say that we are trying to avoid the arbitration. My claim is about 3,000 crores. His claim is about 8,000. There is a counter claim by me. Why should I avoid the arbitration proceedings? Ours is 8,000 crores and my friend's claim is 3,000 crores. Therefore, what we are claiming before the NCLT is only 40 crores, which is the guarantee given by the personal guarantee given by the firm. There is no question of avoiding the arbitrator. Such an impression is created. I am really sorry. Such an impression is being created everywhere that we are avoiding the arbitrator. But your lordships are aware, in a special statute, the equity doctrine is very limited, whether it is a taxation or representation of people. If some right is conferred, I will exercise the right. My conduct that I filed several petitions, but that is totally immaterial when it comes to because this is a special statute. But your lordships are aware, when my friend said it's a borrowed legislation, there was an act called Sikh Industrial Undertakings. Every time a creditor comes against me, I will go before BIFR and there will be total suspension of the entire proceedings, unlimited. Now the limited period is only 41. My friend is talking about the moratorium. The moratorium is a shield against him. It protects him from the onslaught of other creditor. That is what exactly moratorium under section 96 says. But I will only repeat section 96 of the act. It protects him from the onslaught of the other creditors. I do not know why so much is made about the moratorium. But we have dealt with these issues under the SICA, the Sikh Industry, and we would file a petition under section 22 before the BIFR. Everything would come to a standstill. It would continue forever. 96 subsection 1B. Any legal action or proceedings pending in respect of any debt shall be deemed to have been stayed. The creditors of the debtor shall not initiate any legal action or proceeding in respect of any debt. He is projecting as if it is some sort of a draconian act against him. No, it is a protective shield from the other creditor. He should thank me that I am enforcing the moratorium. But personally speaking, the moment I file the petition, moratorium should kick in or not, that's a different thing. But this is the precise argument before the Supreme Court that it affects the principles of natural justice. It confers unlimited power. They lost the case. The Supreme Court upheld the moratorium. And today, the law is the moratorium should kick in the moment an application is filed. And what the entire judgments quoted my learned friend is against the inferior court and tribunal. Number one, against an an order which is which can be tested in a writ jurisdiction under the certiorari and also prohibition. Neither of them apply because paragraph I pointed out, it is against an administrative act of receiving the petition without even going through this 41-day process. It is just 41, that 41 day may be reduced if the report is submitted earlier, if the board nominates the RP earlier, or if the NCLT itself directs the board to appoint the RP earlier, it may be reduced even to 22 days. Therefore, my lord, there should be some sort of, my lord, institutional integrity to be maintained when an authority is conferred with the power. Asking this honorable, requesting this honorable court, my lord, I'm sorry for using the word, to hijack that power and deal with it may not be, my lord, correct. But regarding the arbitration, my friend is participating in the arbitration proceeding. It's, my lord, there.
May I just not pass on? My lord, the procedure. My lord, I have just extracted it from, my lord, the IPC code. My lord, this gives an insight, my lord, what happens when a section 95 is present. And precisely, my lord, answer your lordship's, my lord, question that fell. Your lordship would kindly have, but this is what happens. This is the scheme. I'm not going to read, my lord, entire, but for the sake of confusion, I have extracted everything. My lord, under section once. My lord, under section 95 on page 1, my lord, filing of the petition, section 95. My lord, upon page, prior to for 95, my lord, a notice is issued. A demand notice is issued, my lord. This is in terms of Rule 7.1. My lord, that notice precisely will say this is what is my demand against you, so that I'll go to NCLT if you don't to settle. My lord, that is sufficient notice. At the time when the demand notice is issued, if they feel that, my lord, this is a statutory notice, my lord, without which we can't go to my lord, NCLT. If they feel that a notice is being issued in order to create an illusory case before the NCLT, in effect, if which is filed, it is likely to have all these hazardous effects on me. They are free to take, my lord, all such steps. My lord, I need not to tell them what all they can do. If they issue a notice, my lord, they can clearly foresee an action that is going to fall from my side. They do not, my lord, do anything. They receive notice and they reply. After this, my lord, we go to NCLT. My lord, once a petition is filed, so that, my lord, it is not that to their surprise we get into NCLT. Before getting into NCLT, statute, my lord, mandates us to issue a notice in which we would have told all these things. Look, though there is no direct liability, though there is no direct admission, we are bringing this into the ambit of a debt by following all these things, by treating this in our way like this, etc. All these things, my lord, we spell out in advance. And, my lord, the notice says everything. Once it is filed, my lords, may kindly have page number 1. My lord, on page number 1, my lord, item number 2, filing of application. Section 95, my lord, this traces to 95. Upon failure to make payment of the debt amount, a creditor reserves the right to file an application before NCLT. Application shall be filed in form number so and so, so and so. The annexures, kindly, my lord, see the annexures what we put. These are all mandatory. List of documents attached to the application to prove the existence of debt and amount in default. Copy of demand notice served on the guarantor in form B. Copy of the income tax returns with detailed computation of income of the guarantor or firm for the previous 3 years if available. Copy of the personal guarantee contract. Copy of the authorization whenever required. Proof of the application fee has been paid. Documents evidencing the debt and the default in relation to the debt as may have been provided by the guarantor
at any point of time, if available, documents evidencing the assets, liabilities, income, and any other relevant information as may have been provided by the guarantor at any point of time. Documentary evidence of all information sought in each entry of each part of the form. My lord, soon after this, my lord, the moment it is filed, interim moratorium kicks in. Interim moratorium. Then, my lord, that is, my lord, by virtue of section 96. Then, my lord, fourth item, application filed through resolution professional. My lord, there are two things. One, as my lord, creditor, I myself can, my lord, file, or it can even be filed through, my lord, a resolution professional. Then, my lord, that is 97. In the event the application under section 95 has been filed through a resolution professional, NCLT shall direct the Insolvency Bankruptcy Board of India within 7 days from the date of application to ensure that no disciplinary action is pending against the resolution professional. Within the aforesaid period of 7 days, the board shall communicate to the NCLT in writing either confirming the appointment of resolution professional or rejecting the appointment of the resolution professional. When a resolution professional is rejected, nominating another resolution professional for the insolvency resolution process. Then, my lord, it details what if it is directly filed by us. That is, in the event the application is filed by the creditor himself and not through the resolution professional, my lord, which is in our case, the NCLT shall direct the board within 7 days to nominate the resolution professional from the date of filing of such application. Upon the receipt of such direction from the NCLT, board shall nominate a resolution professional within 10 days. The NCLT shall, by passing an order appoint a resolution professional as recommended and nominated by the board. A copy of the application shall be provided by the applicant to the resolution professional within 3 days. Then, my lord, 5 deals with replacement. Then, my lord, 6, a report to be submitted by the resolution professional, my lord, which is in terms of section 99. The application shall be examined by the resolution professional within 10 days from the date of his or appointment, and the resolution professional shall submit a report to the NCLT, wherein the resolution professional shall recommend the approval or rejection of the application. The debtor shall be required by the resolution professional to prove the repayment of the debt claimed as unpaid by the creditor by way of furnishing evidence showcasing the electronic transfer unpaid amount from the bank account amount of the debtor, evidence showcasing the encashment of the check, and signed acknowledgement from the creditor accepting the dues from the debtor. Further, the information may be sought by the resolution professional and the person from whom such further information may be sought. After all this exercise, the resolution professional will submit a report to the NCLT. NCLT, my lord, would take a call on that, my lord. This is how the scheme is designed. Now, my lord, all the arguments advanced by my learned friend were all, my lord, the arguments that were, my lord, presented even in a better way before the Honorable Supreme Court. Because the interim moratorium kicks in, for none of my faults, why should I be made to suffer? All these were the arguments. My lord, I will not trouble your lordship reading, my lord, several judgments. Only the Jivraj Ka judgment, my lord, attends to all these arguments. Kindly, my lord, have the Jivraj Ka's judgment, my lord, which I have already placed. It's a single judgment, my lord. I have directly placed, my lord, the Honorable Supreme Court printout, not a reported version. My lords may kindly have.
It is reported.
It is reported also, my lord. I have placed, my lord, for the ease of it, my lord, the Honorable Supreme Court's printout.
Citation, do you know?
Yes, my lord.
Which is the citation?
My lord, the citation, my lord, is 2023 SCC online SC 1530.
Not reported in SCC.
It is reported in SCC. It is reported. My lord, for the ease of it, I have, my lord, filed the copy from, my lord, the Honorable Supreme Court archives. Kindly, my lord, have that.
2023 SCC online.
Yes. The page nation is same.
Find out SCC version.
Paragraphs are same. Kindly give me one more copy. Lord, may I just pass on, my lord, the reported version also? Say paragraphs remain the same. kindly, my lord, have this judgment, my lord. Kindly, my lord, have the submissions, my lord, which is on page number, paragraph number, my lord, 23. Paragraph number 23. Open the reported version.
Para 23.
Paragraph number 23, my lord, it is under the heading, my lord, submissions on behalf of the petitioners. Dr. Abhishek Manu Singh, senior counsel, has set forth the following propositions for determination by the court. The IBC is an invasive in rem proceeding and is highly prejudicial against the respondent. Before initiating proceedings for insolvency under the IBC and the appointment of resolution professional, or at the minimum before the resolution professional takes any action, there must be determination by a judicial body of the existence of the debt. Lord, this is what precisely which my learned friend argued now. Then, following ought not to take place automatically after filing of an application under section 95 without judicial adjudication and intervention, namely, my lord, under the act it takes place, but the learned counsel was saying that this should not take place. That is number one, an automatic interim moratorium. B, automatic appointment of resolution professional subject to worthiness. C, resolution professional seeking information from the guarantor. D, the resolution professional examining the information received and submitting a report. None of the above sets once performed is reversible under section 100, which is the first stage at which two crucial steps take place. A, it is the first time at which a judicial body adjudicates, and B, it is the first stage at which the guarantor is furnished with a hearing by the adjudicating authority. The power to seek information not only from a guarantor, but also from the third parties which is made available to the resolution professional is untrammeled and being routinely exercised. Common law consistently provides natural justice unless explicitly prohibited by statute. Any statutory exclusion is subject to review and may be invalidated except in cases related to special reasons like national security. All the petitioners seek in natural justice by a judicial body at the stage of section 97(1), similar to the exercise of adjudicating authority which discharges its function under section 7 and 9 of the IBC. And the IBC follows the same model as sought by the petitioners under section 7(9), and neither any reasonable distinction nor any qualification exists for denying the right to adjudicatory hearing to a guarantor in the same statute when confronted with the application under section 9. Primarily, the submission which has been urged on behalf of petitioner by Dr. Singhvi postulates that the fundamental aspects as to whether the jurisdiction to entertain an application under chapter 3 or part 3 exists must be determined at the threshold by giving the debtor or a personal or a guarantor an opportunity of being heard. My lord, this is what exact, my lord, arguments, my lord, in different words of my learned friend. Then the submission is that logically the determination of the jurisdictional question has to take place first before the appointment of resolution professional under section 97 clause 5. Consequently, it has been submitted that the adjudicating authority must be required to determine at the threshold whether a debt exists or whether a debt has been affected. The submission has been sought to be advanced from two perspectives. Firstly, it postulates that a judicial aspect is involved even before the resolution professional begins the task outlined in section 99 for determining the jurisdictional requirements for the existence and continuity of debt. Secondly, following the appointment of resolution professional under section 97(5), wide-ranging powers are granted under section 99(4) to demand information not only from the debtor but also from the third parties. As a result, the submission emphasizes the need for judicial determination by the adjudicating authority before the stage outlined in section 100. Senior counsel argues that without incorporating a requirement for hearing before the adjudicating authority prior to the appointment of resolution professional, the provisions of section 95 to 100 would be arbitrary and violative of Article 14. Now, my lord, there the argument was, there had the precise demand was, before all these things happen, let a judicial examination happen, which is, my lord, being sought, which was sought under this writ petition also. Kindly see, my lord, what the Honorable Supreme Court said on all these things. My lord, these were about thousands of writ petitions, my lord, on this, the role of resolution professional, the role of adjudicating authority, Everything, my lord, is extracted. Kindly, my lord, see what the Honorable Supreme Court said. Conclusion, my lord, I am not going to trouble, my lord, reading all these things.
Paragraph.
My lord, I am on paragraph number 84. My lord, paragraph number 83 has some importance. I'll come back and read it, my lord, in this context. Kindly, my lord, have paragraph 84. The second incidental submission which was argued is the provisions of section 95 to 100 are retroactive. My lord, I am on paragraph 84, my lord.
The second incident.
Yes, the second incident. The second incidental submission which was urged is that the provisions of section 95 to 100 are retroactive in nature. And since they would operate in respect of guarantees which may have been executed before the statutory provisions were brought into force, it is well settled principle that the law is not retrospective. It is in nature merely because some parts of the cause of action on which the law operates has arisen in the past. Prior to the commencement of IBC, the field was governed by the Presidency Towns Insolvency Act 1909 and the Provincial Insolvency Act of 1920. With the enactment of IBC, the insolvency resolution process in relation to individuals and partnership firms is governed by Part 3 of IBC. The IBC cannot be held as operating in retroactive manner so as to violate Article 14 of the Constitution. For the reasons stated above, we have come to the conclusion that the impugned provisions of IBC do not suffer from any material arbitrariness so as to offend Article 14 of the Constitution. This is subject to clarification on the interpretation of Section 99 in the text of this judgment. Conclusion, my lord, this is important. We summarize the conclusion of this judgment below. No judicial adjudication is involved at the stages envisaged in section 95 to 99 of IBC. My lord, there is no judicial adjudication is involved. Neither the Supreme Court said it is necessary. The need for it was dismissed. The cry of the need for it was dismissed. This was what, my lord, so many petitioners said, no, someone has to look at that before, because unlike section 9, section 7, my lord, the financial debt, unlike section 9 of IBC, operational debt, before, my lord, the moratorium comes in picture, my lord, an order of admission is passed.
So 9 and 7.
Section, my lord, the section 7, my lord, deals with, my lord, financial debt.
So their position is different.
Yes, the provision is different. 9
position is different.
Position is different, my lord. There, the interim moratorium, all these things would step in only after an order of admission passed by the NCLT.
That is against the companies, my lord. Part 2 against the companies.
Now, I'll clarify. Then, my lord, 9 deals with operational debt. There also, my lord, an order of admission. No defendant, no respondent would suffer by the presentation of the petition. Only after an order of admission, my lord, the Honorable NCLT, my lord, would look into the matter, afford opportunity, then pass an order of admission. Then only, my lord, all these, my lord, invasive effects would step in. But unlike that, under section 95, something, my lord, comes in the beginning itself. This was what, my lord, being objected before the Honorable Supreme Court, that this does not pass the muster of, my lord, the fairness. Muster of, my lord, some judicial authority looking at that, there cannot be, my lord, beleaguerment even before a judicial adjudication takes place. This was the argument. Therefore, my lord, after hearing all these petitions, the Honorable Supreme Court concluded. 1, no, my lord, I am on paragraph 86. No judicial adjudication is involved at the stages envisaged in section 95 to 99 of IBC. The resolution professional appointed under section 97 serves a facilitative role of collating all the facts relevant to the examination of the application for the commencement of insolvency resolution process, which has been preferred under section 95 or section 94 or section 95. The report to be submitted to the adjudicatory authority is recommendatory in nature on whether to accept or reject the application. The submission that a hearing should be conducted, my lord, this is important, hearing should be conducted by the adjudicatory authority for the purpose of determining the jurisdictional facts at the stage when it appoints a resolution professional under section 97(5) of IBC is rejected. No such adjudicatory function is contemplated at that stage. To read in such a requirement that stage would be to rewrite the statute which is impermissible in exercise of a judicial review. the resolution professional may exercise the powers vested under 99(4) of IBC for the purpose of examining the application for insolvency resolution and seek information on matters relevant to the application in order to facilitate the submission of the report recommending the acceptance or rejection of the application. There is no violation of natural justice under section 95. My lord, section 95 is the presentation. 96, my lord, is the kicking in of the moratorium. No violation of natural justice under 95 to section 100 of IBC, as the debtor is not deprived of an opportunity to participate in the process of examination of the application by the resolution professional. My lord, the resolution professional gives all this opportunity to the debtor. Then no judicial determination takes place until the adjudicating authority decides under section 100 whether to accept or reject the application. The report of the resolution professional is only recommendatory in nature and hence did not bind the adjudicating authority when it exercises its jurisdiction under section 100. The adjudicatory authority must observe the principles of natural justice when it exercises the jurisdiction under section 100 for the purpose of determining whether to accept or reject the application. The purpose of interim moratorium under section 96 is to protect the debtor from further legal proceedings. My lord, it is in their favor. The Honorable Supreme Court holds that a kicking in of the interim moratorium does not devastate them. It rather, my lord, serves them.
Read again.
My lord, now, kindly, my lord, that is, my lord, Roman 8. The purpose of interim moratorium under section 96 is to protect the debtor from further legal proceedings. Now, my lord, now a picture is projected the moment interim moratorium commences. I will be put to hardship. My lord, this was the argument. My lord, my learned friend, my lord, did use the word civil death. My lord, all these arguments, my lord, vociferously were kept before the Honorable Supreme Court. Supreme Court decided, my lord, no, it does not happen so. It is a beneficial legislation. It would accrue to the benefits of all, particularly to the debtors. My lord, what would happen, my lord, under the scheme? First stage is resolution. Second stage, my lord, the resolution is not possible, and by resolution, if a company cannot be kept alive, or my lord, a debtor cannot be, my lord, kept alive by not being declared as an insolvent, then only comes, my lord, liquidation. Earlier, my lord, the liquidation could happen otherwise. Now, my lord, a clear attempt is made. Now, my lord, attending to the arguments of my learned friend, may I just take your lordship to, my lord, paragraph number 96 for a moment, my lord. Paragraph number, my lord, paragraph number 83. My lord, my learned friend was repeatedly saying that a party is not notified yet insofar as the partnership firms are concerned. We are not on that. My lord, now, against a partnership firm, my lord, we can say that the partnership firm itself is the debtor. Therefore, if we want to proceed, that party is not notified. This was also one of the questions which fell for consideration before the Honorable Supreme Court. Kindly, my lord, allow me to read paragraph 83. Before concluding, it would be necessary to deal with two incidental submissions which were heard during the course of hearing. It is sought to be urged that subsection 2 of 95 indicates that an application under subsection 1 can be initiated only in respect of a partnership debt. For partnership debt which is owed to the creditor. We are of the view that this is not a correct reading of section 95. Subsection 1 indicates that a creditor may apply either by themselves or jointly with other creditors or through a resolution professional to the adjudicating authority for initiating IRP. Subsection 2 provides that in a situation where a creditor has applied under subsection 1 in relation to a partnership debt, the application may be filed against A, anyone or more of the partners of the firm or the firm. The provisions of subsection 2, in other words, cannot control the ambit of subsection 1 of subsection 95. My lord, there is a finding which is, my lord, quite adverse to the arguments advanced by my learned friend. Kindly, my lord, now also come to, my lord, two definitions which were being shown by my learned friend. Definition, my lord, which is contained under section 423. Section 4, subsection 23 of, my lord, IBC, where it defines what, my lord, is personal guarantor. Section, my lords, may kindly. Yes. Now, my lords, may kindly have 522. My lord, personal guarantor is defined, means an individual who is a surety in the contract of guarantee.
Would you read 83 again? Paragraph 80.
No, my lord, I am on, my lord, the definitions in the, may I, my lord, paragraph 83.
What do you want to argue by?
Yes, my lord. Now, paragraph number 83, my lord, it deals with, my lord, particularly, my lord, this section 95 deals with, my lord, the partnership firms. Now, my lord, if today I have to, my lord, initiate insolvency proceedings or resolution proceedings, my lord, against partnership firm in respect of, my lord, a partnership debt, I have to necessarily go before the DRT, and secondly, that part of the IBC is not yet notified. But, my lord, there could be a situation where I am not suing or not bringing, my lord, action under the IBC against a firm for a partnership debt. What if a firm or the partners thereof are incidentally standing as guarantors in respect of a debt of somebody else? Which is precisely, my lord, our case.
But actually it is not here.
It is, my lord. Factually, our case is that. Our case is that.
Supported factually.
May I just, my lord, in this background, my lord, read for a moment, my lord, paragraph 83. Our entire case before, my lord, the I understand, my lord. I understand, my lord. I understand. My lord, I'll just, my lord, say, my lord, 3 lines of facts.
Something is as clear as daylight. And
exactly, my lord. Yes.
And we refuse to recognize it.
I will certainly, my lord, as it fell from your lordship, I will not certainly do a hair-splitting argument, but my lord, I'll just say 4 lines, my lord, the background of this. My lord, there is an agreement which is the basis. My lord, that agreement says, my lord, party A paid a huge amount to party B. My lord, instead of, my lord, I am just putting it illustratively like this. Party A paid, my lord, a huge amount to party B. They entered into a subsequent agreement. Look, some amount of money paid by party A to party B will be considered as a repayable security deposit, which you will have to repay if certain incident does not happen. That certain incident did not happen. Therefore, party B, my lord, party A got entitled to seek for its refund. Look, you have agreed under a particular agreement that I am entitled to seek for the refund of it with interest of so-and-so amount. Because it did not happen, they went on serving demand notices. And the demand notices, my lord, swell up to the extent of about 811 crores. These are the demand notices which you have failed to do. Now, my lord, there is a section 7 is also filed before, my lord, the NCLT, in which the notices have already been issued yesterday. Now, to this principal debt, a firm and its partners were also parties, as evidenced by that very agreement. As evidenced in that very agreement, that firm and its partners. That's the reason, my lord, my learned friend was submitting, my learned brother was saying, the import of, my lord, the provisions of Partnership Acts and the import of, my lord, provisions of Contract Act is embedded in the code itself, because the code felt, my lord, that let us not simply go on making the code bulky by extracting whatever that is there under the contract. We will simply say, by virtue of a particular section, that whatever that is not dealt, whatever that is relevant under the Contract Act and under the Partnership Act, we will straight away import by virtue of a straight provision. Now, my lord, the IBC will have to be necessarily read in conjuncture with Contract Act and with the Partnership Act. My lord, only 2 submissions. Under the Contract Act, my lord, my learned brother was, my lord, wide enough to say that a guarantee need not to be a specifically worded, all clear guarantee. It can even be a presumable guarantee, an oral guarantee. But in our case, there is a guarantee. Secondly, my lord, the submission is under the Partnership Act, for the acts of the partners, everyone are individually liable. If it is a guarantee, every partner is a guarantor. My lord, this is how the petition is presented, and all this was told under the very notice, the Rule 7 notice. Now, if you had any such apprehensions that this Rule 7 notice is clearly a beginning of IBC, I am going to go into the IBC, they could have gone to, my lord, a civil court and sought, my lord, an order of injunction restraining us, my lord, by way of an anti-suit injunction, my lord, which is available to them. That remedy is available. If any party proposes to, my lord, trigger a judicial remedy before a court, if I feel that such a remedy is likely to jeopardize me because the arbitration is going on or whatsoever, you are entitled for an anti-suit injunction, which you did not do. Then once I file it, you come before a writ court and say, no, they are trying to create an illusion of a guarantee. Even I would go a step further and say, if I have created an illusion of a guarantee, if I have created an illusion of, my lord, a liability on a partnership firm, not as a partnership debt, but the partnership firm and its partner acting in the capacity of personal guarantor, who has to look into this? The RP will issue notices, will solicit their response. They can say, and under section 100, they can go before the NCLT, and the NCLT, my lord, principles of natural justice are met by virtue of Jivraj Khan, by virtue of the very act itself. NCLT will hear, my lord, these are all summary questions. NCLT will simply look into the documents, determine itself that my claim is illusory or not. And kindly see, my lord, the strength of, my lord, IBC. If the NCLT feels that I have misused, created illusion, like Arivandandam's case, they can proceed against me under section 65, my lord, which is misuse of the law, which has, my lord, penal consequences against me. And, my lord, all these things are embedded and kept under the IBC itself. My lord, very kindly, my lord, have page number 685, my lord. Kindly, my lord, have volume 2, page number 685. I'll only, my lord, show to your lordships the design of this agreement. Page number 685. Now, my lord, this is an admitted document. Page number 6.
Before you go, paragraph 83, what we wanted to convey?
83, my lord. May I now read, my lord, in this background, 83. Paragraph number 83, my lord, in this background.
What you wanted to convey an argument?
My lord, under 83, I just want to, my lord, convey this. Was the Honorable Supreme Court ready to accept an argument that except partnership debt, except partnership where the firm itself is, my lord, the debtor, not in the capacity of guarantor, except that, can a 95 not lie? My lord, the answer is this. Before concluding, my lord, I am just reading paragraph 83 of the judgment Jivrajka. Before concluding, it would be necessary to deal with two incidental submissions which were heard during the course of hearing. It is sought to be urged that subsection 2 of 95 indicates that an application under subsection 1 can be initiated only in respect of a partnership debt which is owed to the creditor. We are of the view that it is not correct reading of 95. Subsection 1 indicates that creditor may apply either by themselves or jointly with the other creditors or through a resolution professional to the adjudicating authority for initiating an IRP. Subsection 2 provides that in a situation where a creditor has applied under subsection 1 in relation to a partnership debt, the application may be filed against A, any one or more of the partners of the firm, or B, the firm. The provisions of subsection 2, in other words, cannot control the ambit of subsection 1 of subsection 95. My lord, in fact, the Honorable Supreme Court was also trying to dissect between, my lord, the firm. My lord, unlike, may I say this, my lord, as my lordships are kindly aware of this, unlike a company, my lord, which has an independent existence even without the directors or shareholders, etc., everyone Solomon and Solomon, a partnership, my lord, will not continue to exist if there is even a slight departure of one of the partners. Therefore, the Honorable Supreme Court was, my lord, posed with the situation, though it is a precise extract, much of the arguments were advanced before the Honorable Supreme Court. I was also a part of that. To say that, look, this kind of incidents may happen. Dismissing all these things, Honorable Supreme Court said, we are not throwing you out of tenets of judicature, but you have remedy to go and voice out your grievances. It is not that your doors are shut. The courts are there to hear it at an appropriate time. At the time when the NCLT hears, adjudicating authority hears. My lord, two more. My lords, kindly have page number 685, my lord, for a moment, of volume 2. I'll have only one submission on this. Page number 685, my lord, is precisely this agreement, on the basis of which, my lord, we have gone to the NCLT, on the basis of dues arising out of this. My lord, I'll conclude, my lord, in next 2-3 minutes. I'll.
Now we can continue another day if it is. There is no time. Neither we are bound by time, nor your argument. You are free to submit.
I'll, my lord, close it in 2 minutes, my lord.
Ultimately, we have to understand, at least myself. Yes. Yes.
I'm so grateful, my lord, for this interactive hearing. My lord, page number 685, my lord, is the document.
Yes.
My lord, this is an admitted document under which, my lord, some claims and liabilities are created. And the parties to this is two entities. Number one, my lord, is the company, Manyata Infrastructure Developments Private Limited. Number two is the Manyata Realty. Manyata Realty, my lord, is, my lord, liable for Manyata Infrastructure. Manyata Infrastructure is liable for Manyata Realty, my lord, because acts of, my lord, my lord, participants to your application. Now, my lord, this agreement clearly provides that if a certain amount is not paid, what all has to be done. Now, lastly, my lords, may kindly have, my lord, this two, my lord, only one definition was read by my learned friend. That is 522, which defines personal guarantor means an individual who is the surety of a contract. My lord, the emphasis was laid on individual. So if it is not an individual, there cannot be, my lord, a move against the personal guarantor. But, my lord, section, my lord, 323, my lord, defines what is a person. Person includes an individual, a Hindu undivided family, a company, a trust, a partnership. Both the definitions have to be read together, my lord. Otherwise, reading only one definition, my lord, would give a myopic view of it. My lord, under no circumstances, the makers of IBC could have, my lord, left out a large part of it. A large part of it, my lord, being escaped from its, my lord, sphere just because of one, my lord, definition. That's the reason, my lord, two different levels of definition. One has to be read, my lord, in corollary to each other. My lord, my humble submission is all these arguments which are addressed by my learned friends was dealt under Jivraj Ka's matter. The learned single judge, my lord, would now say, if I have presented altogether a wrong petition by creating an illusion, by creating an illusory jurisdiction, just in order to exploit that moratorium or whatsoever, it should be dismissed in limine by exercising, my lord, the powers of issuing prohibition. Can that be done? My lord, the Honorable Supreme Court was confronted with the same situation. If, my lord, the judgment of the learned single judge, my lord, is let to continue, it would, my lord, undo the effect of, my lord, the law declared by the Supreme Court under Jivraj Ka. Then, my lord, everyone would come and say, my learned friend may have a great case of, my lord, alleging against me an illusory claim, but every case, my lord, tomorrow will come and say, no, this entire application is illusion. Please get into this. And at the end of the day, to do what? Under 226, to dissect into the facts, which is, my lord, in my humble submission, my lord, is impermissible. My lord, therefore, my humble submission, my lord, is the judgment of the learned single judge, my lord, in my humble, my lord, say, runs, my lord, contra to the law already declared by the Honorable Supreme Court. Therefore, my lord, it cannot be sustained, my lord, is my humble submission.
Anything is there?
Well, I'll make my written submissions. I'll not trouble you.
No, then Monday.
Monday, my lord. So grateful, so grateful.
Anything to be added?
I can also, my lord, give us.
By the time you can prepare.
Yes.
It's a short summary, Monday, my lord.
Both of you can.
Yes.
Oblige.
The arbitration, my lord, is continuing. The allegation against us, we are doing all these exercise in order to, my lord, somehow or the other, my lord, stop the arbitration. In fact, which is not our concern. the arbitration, my lord, it should have been stopped for the legal need. That is, there is a moratorium, rightly or wrongly. Tomorrow. So great.
I owe an apology, my lord. I'm troubling my lords. Today morning, I moved the matter. That one common judgment, my lord, two petitions, two writ appeals have been filed. My lord's given date, one memo on 5th, my lord. Same, one more matter is there, my lord. The same date, that may be coming to the same day, my lord. Fifth, common, 5th. I'm sorry, my lord.
May I make an? Number 8 for withdrawal, Harish Bandari T.
Drawing. Learned memo is there.
Memo is there, Worship.
On the page of the memo file, the page of the, on the pages of memo dated so and so, which figures on memo dated 10/20/6/23, which figures on record, learned senior advocate Mr. So and so, seeks permission to withdraw the petition, withdraw the contempt petition. The memo mentions that the endorsement dated 19/6/23 is received and the where of the complaint is rejected. It stated that the complainant has to proceed to challenge the said endorsement. Such liberty is reserved for the petitioner, however, expressing any opinion on the merits of such recourse. Since the directions are complied with, from on the contempt petition does not survive and dismissed as withdrawn.
Liberty to challenge that.
We recorded what you recorded, we stated in memo.
Number 9, Mohammed Tahir. Tahir.
Hearing for the government, my lord.
Learned counsel for there. Lost matter. Monday too.
Make an
Yes,
appeal to your lordship, my lord.
Till
number 53, my lord.
Yes.
Item number 10 is by next item. But date may be.
Date will be given.
So my
No.
own. 44 become infectious.
44.
44 may be closed.
Learned counsel, Mr. So and so makes a statement that the subject matter of this petition, it is petition.
Yes.
So infectious. In that way, he requests the court that the matter may be disposed of, dismissed as infectious.
Serial
May I
number
make an
51.
appeal to your lordship, item 53, matter pertain to contract, my lord. Tender is allotted to me. I invested 10 crores, my lord, my client, lord, there is a stay order, my lord, running against me. My lord, last occasion.
Get the date.
My submission at
kind permission, my lords. There's a memo for posting, my lords. This is regarding a contempt petition that was disposed of with an undertaking, my lords. However, they've not complied with that undertaking.
Belongs to this bench.
This bench, my lords.
Because whenever we again sit, we'll list it.
Very well, my lords.
In fact, you have to go to the registrar.
Because in fact, we went to the registrar, they directed us to.
Just forward this memo to registrar judicial. We will make submission.
Grateful.
1586 of 2023. Notice for VTU.
Pardon?
I mean, permitted to take notice for VTU respondent to university. University panel policy.
In this matter.
Please. My name is not shown.
Notice and time both.
I will appear for the VTU. Kind permission. Further hearing matter. I seek permission before.
So accept not.
Notice for VTU.
Yeah, university. For which day? He request time. So some other day.
No, I will assist the court. I am prepared with the matter because I appeared before the learned single judge.
Even today you are assisting?
Yes, even today also I am prepared to assist.
So you want time or you want to proceed?
No, I will be present before the court while arguments are going on. Now, whenever I have not much to say in the matter.
You come with.
Please. My role is very limited, Lord. I only implemented the government order, the notification, withdrawing the nomination.
Other day. Today, let him in his presence so that at one go we can complete.
Very well.
Please.
I leave it.
July will be.
Please.
Fine.
Please.
Please.
10th July, 2:30 or 4 o'clock?
I'm entirely. I was very happy that I'll have a full session to go.
Yes.
Please.
Ten.